Good morning, my name is Maha Al-Shabul 22047170. In this video, I will be discussing the remedies available to buyers under the Sale of Goods Act 1979. This legislation is crucial as if you're a consumer or a business purchasing goods, it's essential to understand your legal rights when things go wrong. By the end of this presentation, you will hopefully have an understanding of the remedies available to buyers when things go wrong with their purchases. Let's begin. Right to reject goods under the Sale of Goods Act 1979. Buyers can reject goods outright if there is a fundamental breach by the seller. The right to reject is crucial when goods do not conform to the contract or when delivery does not meet the agreed upon terms. This right is enshrined in Section 35 of the Sale of Goods Act 1979. So the right of partial rejection, which is in Section 35A. So the Sale and Supply of Goods Act 1999 introduced Section 35A, which allows buyers to reject part of the goods while keeping the rest. This is particularly useful in bulk purchases or cases where only some of the delivered goods are defective. For example, a buyer orders 500 LED screens for resale, but 50 arrive damaged. Under Section 35A, the buyer can reject the 50 faulty screens while keeping the remaining 450. However, the right of rejection is restricted for minor breaches in commercial transactions by Section 15A. If a breach is so minor that rejection would be unreasonable, it is treated as a warranty breach, meaning the buyer can only claim damages. So, Commercial Unit Rule, Section 35(7). So the concept of a commercial unit prevents buyers from rejecting part of a unit if it would affect the value of the whole. Examples include a set of dining chairs. Rejecting one chair out of a 6-piece set affects the value of the whole. A pair of shoes. One defective shoe renders the pair useless. A shipment of grain. Dividing a bulk shipment may affect its overall quality and marketability. If a buyer accepts part of a commercial unit, they are deemed to have accepted the entire unit. So, damages for non-delivery, Section 51 of the Sale of Goods Act 1979. If a seller fails to deliver goods, the buyer can seek damages under Section 51 of the Sale of Goods Act 1979. So, Section 51(2), the buyer is entitled to damages for any direct loss resulting from non-delivery. Section 51(3), if there is an available market, damages are calculated as the difference between the contract price and the market price at the time of breach. So key cases on non-delivery damages. So first of all, Hadley and Baxendale, 1854, established the two-limb test for damages. So losses must arise naturally from the breach or be reasonably foreseeable by both parties. Victoria Laundry and Newman Industries, 1949, the buyer ordered a boiler for their laundry business. The seller was late delivering it. The buyer claimed damages for lost profits, including potential government contracts. The court held only ordinary losses were recoverable, as the seller was unaware of the special contract. This case highlights the importance of foreseeability in claiming damages. Williams and Agius, 1914. The buyer had already agreed to resell the goods to another party. The court ruled that market price rules still applied. The resale contract did not affect the damages calculation. If no market exists, the buyer's actual losses determine damages as seen in R and H Hall and W.H. Pym, 1928. The buyer successfully claimed the difference between the contract price and their resale price, since the contract specifically provided for resale. So the key takeaway is that buyers should document losses clearly to strengthen their claim. So, damages for breach of warranty, Section 53 of the Sale of Goods Act 1979. When a breach does not justify rejection, buyers can still claim damages under Section 53 of the Sale of Goods Act 1979. So, Section 53(1), the buyer can set off the breach against the price or sue for damages. Section 53(2), damages are assessed based on the direct financial loss from the breach. Section 53(3), in cases of defective goods, damages are calculated as the difference between their actual value and their expected value. Key cases on breach of warranty: Bent's Graphics and Fason, 1998. A printing company bought vinyl for outdoor advertising. The vinyl faded prematurely, making their signage unreadable. Damages were based on the loss of value to the end user rather than just the cost of the materials. Bunge Corp and Tradax, 1981. So late delivery of goods was deemed a serious issue in a commercial contract. The court ruled that in business transactions, time is usually of the essence. If a buyer relies on timely delivery to fulfill their own contracts, damages can be substantial. So practical implications: buyers should check whether their contract states time is of the essence. If time is crucial, a late delivery may allow for contract termination rather than just damages. So while the Sale of Goods Act 1979 provides strong protections for buyers, the Consumer Rights Act 2015 introduced the more comprehensive and accessible rights for consumers, especially in cases of defective goods. So why was the Consumer Rights Act 2015 introduced? Prior to the CRA 2015, consumer rights were spread across several pieces of legislation, including the Sale of Goods Act 1979, the Supply of Goods and Services Act 1982, the Sale and Supply of Goods to Consumers Regulations 2002. The CRA simplifies and strengthens consumer rights by bringing these rules into a single modern framework. Key consumer rights under the CRA 2015 include the 30-day right to reject, Section 22 of the CRA 2015. Under the Sale of Goods Act 1979, buyers had to reject goods within a reasonable time, which was often unclear. The CRA 2015 replaced this with a clear 30-day rule, allowing consumers to return goods for a full refund if they do not meet statutory requirements. For example, if a consumer buys a new smartphone but it has a faulty screen, under Section 22 of the CRA 2015, they can return it within 30 days for a full refund. Digital content rights, Section 16 of the CRA 2015. Before the CRA, digital content, for example, downloaded software, ebook streaming services, was not covered under the Sale of Goods Act 1979. Section 16 of the CRA 2015 now provides consumer protections for defective or faulty digital content. For example, if a consumer purchases a video game that keeps crashing due to a fault in the software, under Section 16 of the CRA 2015, they can request a repair, replacement, or a refund. So the right to repair or replacement, which is Section 24(5)(a) of the CRA 2015. Under the CRA 2015, if goods are faulty, the seller must offer at least one repair or replacement before the consumer can claim a full refund. For example, if a consumer buys a washing machine which stops working within 3 months, the retailer must offer a repair or replacement before a refund is considered. At Mayfield Solicitors, we provide expert legal advice on buyers' rights and remedies. If you need assistance with a dispute, contact our team today for professional guidance and support.